Nowhere in the independent history of India, people ever protested against a summons by the ED department, the Enforcement Directorate. Now, it's very clear that it is only to harass everybody. And then it's a potential weapon in the hands of the ruling party because you defy the rule of law, you defy the criminal procedure code, and therefore one has to protest. Justice is delayed, justice is denied. And what happened today is number of serious issues which came in the last 3 years, where the Modi-Shah government is ruling the roost. We have the Citizenship Amendment Act, we have Jammu and Kashmir bifurcation, we have the illegal detentions in Kashmir, we have the 2 union territory status given, that is also in court. Every major issue is today in court, and the courts are not deciding those cases, are postponing it. When you don't believe in the state, when you don't believe in this constitution, why are you now arguing all these points? Then the Kannur gave a correct answer. He said, my lord, it is not the question of that woman or that man does not have faith in the constitution. The question is whether you have a faith in this constitution deciding this case.
ഇന്ന് നമ്മോടൊപ്പം ഉള്ളത് ജസ്റ്റിസ് കെ ചന്ദ്രു ആണ്. മദ്രാസ് ഹൈക്കോടതിയിലെ ജഡ്ജിയായിരുന്ന ജസ്റ്റിസ് കെ ചന്ദ്രു തൻ്റെ ഔദ്യോഗിക ജീവിതത്തിനിടെ 96,000-ഓളം കേസുകളാണ് തീർപ്പാക്കിയിട്ടുള്ളത്. നിയമജ്ഞൻ എന്ന നിലയിൽ മാത്രമല്ല, തമിഴ്നാട്ടിലെ വിദ്യാർത്ഥി രാഷ്ട്രീയത്തിലെ മുൻനിര പോരാളി കൂടിയായിരുന്നു അദ്ദേഹം. ഇന്ന് സ്വാതന്ത്ര്യത്തിൻ്റെ 75-ാം വാർഷികം ആഘോഷിക്കുന്ന ഘട്ടത്തിൽ ഇന്ത്യൻ നിയമവ്യവസ്ഥ ഒരു പ്രത്യേക അവസ്ഥയിലൂടെയാണ് കടന്നുപോയിക്കൊണ്ടിരിക്കുന്നത്. ഇന്ത്യൻ ജുഡീഷ്യറിയുടെ സമകാലിക നിലപാടുകളെക്കുറിച്ചും തൻ്റെ ഔദ്യോഗിക ജീവിതത്തെക്കുറിച്ചും നമുക്ക് അദ്ദേഹത്തോട് അല്പം സംസാരിക്കാം. So in the last few years, we have had verdicts from all levels of judiciary which seem to be supporting a particular political project. Even now we had a verdict regarding broader powers for ED. So in light of all these verdicts, we are now in the 75th year of independence. How independent is the Indian judiciary now?
Because we are associated with this judicial world, both as a lawyer and as a judge. And in my experience in the last 40 years, nothing is shocking because it's in a series of expectations which comes and gives more shock to the people who are democratic minded, who think the courts are meant to give some progressive judgment, really interpreting the spirit of the constitution. Ever since the Ram Janmabhoomi verdict came, that faith is completely removed. And we see a series of judgments on 2 ways. One, don't decide, and if you decide, this will be the result. Now, if will be the result means, I can give you 2 instances. The first case relates to the Money Laundering Act. Now, one curious interpretation that there is no FIR when the Enforcement Directorate gives a report. It's not an FIR. Why they want to keep it away from the criminal procedure code is only because the other provisions will follow. Now, when the Enforcement Directorate calls party to appear in their office, is it a routine attendance? Our criminal law is very clear. It is for the state to find and prosecute people, not get from accused whatever they want. That's why even British, when they drafted the Evidence Act, they said statement given to the police not valid. Now this new judgment says they are not police. So the Enforcement Directorate, which makes you to come and attend their office all the time, they don't call it as an arrest. Now what is it? That means there is an attempt to take away the existing valuable rights which people have under law, namely the procedural right, is now sought to be perverted in the name of new legislation. Now the emotional or the sentimental support is given that money laundering is worse than terrorism. All right. White collar offense should be treated like any other IPC offense. All right, good. But does it mean that we devalue the minimum safeguards given to an accused? Now this is a fundamental question which keeps coming all the time. We had the Tada Terrorist Act. After a lot of protests, it was repealed. Though it was upheld by Supreme Court by a 4:1, one judge, dissenting judge, gave the warnings how the law can be susceptible for misuse. Then POTA came. It did not last long because they got to compromise several issues, therefore it was also withdrawn. Now, 1967 Congress made Unlawful Activity Prevention Act, made with more teeth, more deadly provisions. Now that is ruling the... Now what is the thing is, you do not have a bail provision. You do not have a default bail if you do not file the charge sheet within a particular period. Therefore, it's elastic. It gives too much leeway to the investigation agency, thereby leading to the harassment. We saw in the Bhime Goran case, Anand Telumde and several other intellectuals were inside for 3 years without bail. And we also see that no charge sheet has been filed. Now, if added to that one more weapon on the PMLA, we see the opposition leader Sonia Gandhi being summoned every day, Rahul Gandhi being summoned every day. One small case, how long for the police to question the accused? First, you are perverting the law, because the law doesn't permit such a questioning extensively. Secondly, you try to harass. The intention seems to be nowhere in the independent history of India people ever protested against a summons by the ED department, the Enforcement Directorate. Now, it's very clear that it is only to harass everybody. And then it's a potential weapon in the hands of the ruling party because you defy the rule of law, you defy the criminal procedure code, and therefore one has to protest. Now, what is very joking is, on the one hand, people talk about bail. In Bhime Goran case, in Kappan's case, there is no bail at all granted. Now, you got to struggle, engage some top lawyers. Now, what is happening is another bench now says there seems to be a lot of contradictions. So let us have a bail act. In fact, it was Justice Krishnaiyer who said bail is a rule, jail is an exception. And the old CRPC and the 1973 CRPC both contain bail provision, 438. 1973 CRP added anticipatory bail as an additional safeguard. Now you make several special laws where you say, notwithstanding anything contained in the CRPC, this will be the law, which means every rule you create an exception. Exception becomes the general rule today. Therefore, if you say there is a bail act, where is the bail act? And another Chief Justice now says, this majority people are in the jail are only pre-trial accused and not the post-trial convicts. Government has to do something about it, number one. Another judge says, India seems to be satisfied only with the pre-trial detention and not post-trial convictions. So everybody speaks for the world and not for the real purpose. Now, who said there is no bail provision? If the bail provision is there, but then why people are all languishing? In fact, the United Nations pointed out in the Sustainable Development Goal, 60% of the people are in jail or under trials in all the member countries. Therefore, there is something, a perversion or an erosion of a system, which I do not think that few lectures by Supreme Court judges will ever change. And the Parliament, as it is, hardly any discussions are allowed, will be able to make a law which can give a minimum human rights standard, which we do not see. And the judges seem to think that they will have to ignore the real life situation, the real constitutional spirit in these laws. On the other hand, they try to give some cliches that money laundering is more dangerous than terrorism. All right, that's your view. And that is what very sad. So I come back to your question. Now, what is happening today? In fact, Krishnaiyer very clearly said, there may be one Supreme Court, but within that there are 34 Supreme Court. Now, each bench takes a different stand. Each bench says whatever they feel like. Therefore, the press conference held by 4 judges, led by Chalameshwar and Ranjan Gogoi, that the unusual powers are given to the Chief Justice of India to allot work, which also determines the outcome. Even recently, Kapil Sibal, who defected from Congress to join Socialist Party, one of the senior lawyer, he has said, we won't get justice from the Supreme Court anymore. We feel sad. And the people should not go back to court. No faith must take to streets. That's what he is saying. One congressman and an ex-congressman and present-day socialist speaks like George Fernandez. This may be for press reason, but we must go to the bottom of the issue. Today, the Supreme Court does it function within the spirit in which the Constitution has been enacted and the power has been given to the Supreme Court.
So, what do you think the fallout will be? Maybe in a few years, because there are so many harsh laws being enacted against, as you said, human rights activists, journalists, people who dare to speak out. So, how is this going to shape the country in a few years?
Very shocking. When Ranjan Gogoi, after Chief Justice of India, accepted a nominated MP post, the first thing he did was to write a biography. And more curiously, he gave a title, Justice for the Judges. What does it mean? The judges don't have justice, there is one question. Secondly, that it is not cash for orders. Like the Jharkhand MP's defection, there was an allegation somebody took money to say something. That it was not pursued further. But I am only saying when a justice is denied, justice is delayed, justice is denied. And what happened today is number of serious issues which came in the last 3 years, where the Modi-Shah government is ruling the roost. We have the Citizenship Amendment Act, we have Jammu and Kashmir bifurcation, we have the illegal detentions in Kashmir, we have the 2 union territory status given, that is also in court. Every major issue is today in court, and the courts are not deciding those cases, are postponing it. Even coming to Kerala, a 4:1 majority decided that women can visit Deshabhimani and pray to the Ayyappa. Now what happened to the judgment? It goes to a 9-judge bench for a review. And then when will the review be heard? In fact, last time when I came to Kerala some few years back, I saw one Mahila Madilgal, women wanting to implement the order, and there is nobody to implement the order. Therefore, if you write an order only for academic purpose, it does not going to serve. An order of the court, of the Supreme Court, has to be enforced under Article 142, both by police and civil administration. Where is the administration? Therefore, what is today happening is that the judges come and decide on their own, whatever matters come to them. The essential matters, which is going to decide the destiny or even the outcome of the next general election, that is being postponed. Therefore, the language is very clear, the message is very clear, that we will not be bothered with these matters. Just learn to suffer yourself. What happened when Sitaram Yechury filed a petition for Tarigami, ex-MLA of the Jammu and Kashmir Assembly? Habeas corpus, what happened? It became infructuous. Most of the habeas corpus became infructuous, even though it was filed under Article 32. And therefore, we are reaching a situation where it becomes very dangerous and disturbing. And recently, the Amartya Sen, a Nobel laureate, he said in Calcutta that the judges or the judiciary in India failing to recognize that this country is being fragmented by various actions of the government. And the judiciary is failing to recognize this aspect. Now, judiciary, which has been given enormous power to have a check on the executive incursion or the political incursion into the constitution, instead of safeguarding the rights of the common man, instead of safeguarding and preserving this democracy for future, just going for a holiday or just not deciding matters. This is very causing a lot of concern for any person who believes in democracy. This is especially when we are going to celebrate 75th year of Indian independence. Remarkable that in this subcontinent, the only country which has stayed more stable than any of the other neighboring states. But within this state, there can be a problem which are manifold, and anybody who is concerned with courts and law will think that it is not the same old Supreme Court.
We already have several provisions in our laws for women, for the LGBTQ community, for minorities. But as a modern democracy, in the present day, how do you think these provisions should be improved upon? What is lacking? What should be brought in?
Gender justice is something like a spirit found in Article 15, 16 and also largely said in 14. What today happens is something quite different. Now, we have several laws relating to women which are enacted during the British period and post-British period, immediately after the Constitution came. What is unfortunate in this country was when British came here, instead of making law in a cosmopolitan sense, they adopted the religious twist to every law relating to marriage, property, succession, adoption, guardianship, anything that you matter. Therefore, the laws had a very religious orientation. Though Article 25 talks about Parliament has power to amend provisions relating to religion in the larger interest of public health, public order and morality. And why is that they are lagging behind? When we talk about these issues in open, suddenly you have a portion saying we must have a uniform civil code. That's not the answer at all. What is the answer is that a woman should have a fundamental right to stand, speak and be as a woman. And then the law should reflect that aspiration. But we do not have. Even recently you see the abortion law. We may say that America is much worse than us. Therefore we are happy. We are not happy. But the America, a 50-year-old position has been changed by saying Constitution did not have all these things. Therefore the original Constitution. If you look at that argument, our Constitution also has been amended 102 times. It is because Constitution is not a scripture. And every aspiration of the people has to get reflected, and therefore amendments are always welcome, subject to challenge in court, whether they are anti-constitutional or not. Now in our country what happens is, an unmarried woman has a different abortion right and a married woman has other problem. Same thing about marital rape. You are reluctant to accept the fact, though the rape is defined in the IPC, but then you will not apply to it because there is a Mangala Sutra in her neck. Does it mean that small yellow thread can separate that woman from another woman? Therefore, we have very complicated issues which are to be really seen in the larger context of women's emancipation, women's equal right. That we'll have to argue in those things. On the contrary, when special laws are made to protect women from torture, from ill treatment, like the dowry law, like the Domestic Violence Act, now judges start saying this is being misused. Even before a law is put to use, being misused. Now, how do you say that? Therefore, judges also need some orientation. That orientation should be such that persons who are recruiting to the higher judiciary must have a certain outlook. You cannot say that he so-and-so, their son, so-and-so's relative, nephew, this senior, junior, all that. This old boys club idea should go. When a man takes over the position of a judge, he has to believe in Constitution. That's the oath that he takes. I'll uphold the Constitution without fear or favor, without ill will. But then what happens is the opposite. Every fear is there, every ill will is there, every bias that has been reflected. Why such a thing happens today? That is, even on POXO, many happen, or a person who rapes and then want to get married. Then where do you stand on that? There are many questions are today unanswered than what it used to be before. We always used to think women's questions are hardly being addressed. That when it start being addressed by legislature from outside, now judiciary works in a different sense. They start saying this law is being misused, that law is being misused. And then even they said about the SC/ST Act also, that we will have a anticipatory bail. We will have a police officer giving permission to prosecute. Where do you get all this? So when it suits them, they bring external aids into a special legislation. When it doesn't suit them, they ignore and then go to foreign country for lectures. This is what happens.
So as a judge, as somebody who has been in law for so long, how have your political beliefs or your set of values, how have they shaped the way you approach the law?
For a higher judiciary, there is no conduct rules. And as Rajinder Sachar said in his biography, when during student days, in our youth days, we are also conditioned by various ideological perception. You cannot shed when I decide a matter. There is nothing shame about it. We take a oath that we will protect the constitution. So within that norms, your original experience relating to several issues, class issues of workers or gender issues like women will come, you may take a position. That's not because that you had this ideology earlier. That is because that is your correct understanding. But there are some judges who understand the constitution in different way. Recently I found there was an Naxalite woman who is seeking for bail and she has been kept under POTA which has been repealed. Okay. And her case has been pending for last 20 years. She is still jailed. When her bail petition came second time, after several rounds, the judge asked the question, you do not believe in the constitution, why do you want a bail under this constitution? I remember in the early 70s, when Mr. Kannur was arguing before the Andhra Pradesh High Court, a judge asked a similar question. When you don't believe in this state, when you don't believe in this constitution, why are you now arguing all these points? Then the Kannur gave a correct answer. He said, my lord, it is not the question of that woman or that man does not have faith in the constitution. The question is whether you have a faith in this constitution deciding this case. I may have a very vociferous, different kind of people coming before me with different set of ideology. What I am deciding is whether they are entitled for bail or not being influenced by what is their mental makeup. Now what happens today is, you will have to do a lot of debriefing to the judges, that the baggages which they carry has to be debriefed. It does not mean they should not carry any baggage. My understanding of politics, my understanding of history, my understanding of literature, that also carries along with me. Now, why I should give away? Some people say that we should not have a committed judge. We are not talking about, as Krishna very correctly said, commitment to what? If it is a commitment to the constitution, will come. The constitution preamble clearly says that it is a socialist and secular government, democracy. India, we ourselves gave this country a constitution which by forming a socialist, republican, secular socialist democracy. Now these two words has to now subsequent amendment to the Representation of People's Amendment Act. Every party which believes in socialism and secularism alone can contest in election. If you see the BJP constitution, first paragraph, very laughing. BJP says, I believe in socialism. BJP says, I believe in secularism. Now every company, even the Navaratna public sector are being sold to Adanis and Ambanis. That is socialism. And secondly, secularism. What does secularism mean to them? Today, every hate politics is being introduced in the public sphere, thereby destroying the very... Therefore, if there is a chance, the Election Commission must derecognize that party. Being the stated position in your constitution is secularism and socialism, but your actions are contrary to that. Therefore, you are derecognized. The power is with the Election Commission also. You can't outwardly do lip service and then start running only for contesting election. Now, if one political major party does certain things which are contrary to their own internal understanding, who can help is the judiciary. Now, if you see judiciary in the last 20 years, they seem to be wedded to the concept of privatization, liberalization and globalization. So, when actually a case came before them, a labor case in 1978, there is a Supreme Court judgment which says, what is socialism? It means several things to several people. Though you label it as a socialist country, but it is only a semi-capitalist country. This is what I find in the judgment itself. In the Bangladesh constitution, under Article 7A, if somebody denigrates the constitution, somebody insults the constitution, they can be given death sentence. We do not have. We have a right to criticize the constitution because it's a dynamic document. But you cannot understand something saying that I will uphold the constitution, I will uphold the constitution, but then write the opposite. So every privatization has been rejected by the Supreme Court. Comes to secularism, you have a very shocking interpretation that even the concept of Hindutva is part of secularism. Now, where do you get all these things? That is why I am saying, when you appoint judges, they must be really wedded to the Constitution. They should feel that in letter and spirit they will uphold the Constitution. If that you call it as a commitment, Krishna here said, we should be proud to have such committed judges.
And this question is for our young comrades mostly. So, would you please recount your SFI days for us?
See, as has happened in Kerala, whether campus should have politics or not, finally Supreme Court said, all right, they even consulted a policeman, Raghavan. Finally, they said you can have political-based elections also because people should understand. And subsequent to our SFI days, now the voting age has been reduced, now 18 years. So, technically, a student in the campus also elects his leader. You can't say we get depoliticized. But we were fortunate in our student days to get political orientation, political awareness. That helped us in a big way, not just as a student leader or our lawyer days. Even as a judge, we could think that these issues, the fundamental values, continue to guide us in our decision-making process. I will never say these are all cliches. No, it's not. In that age, to get certain basic ideas, certain basic faith, like for example, class hatred. We never had class hatred. We were made to believe that all classes are equal. Though it talked about overthrow of an exploitative regime, but in terms of working class and agriculture, there is a certain amount of dignity is there, which we are, every issue that we have been learning or we learned during our process, which guided us throughout. That nobody can forget that.
Was there a particular person, particular incident that that influenced you very much in those days? Maybe shaped you, if I can say so.
One thing is that when you go to law college, it may not be a choice that you want to become a lawyer. Very few people will have relatives, kith and kin, who will be doing law or having a flourishing firm. They also want to continue like a successor. Most of us come from families where hardly such orientation is there. But then once you become a law student, once you learn law, especially during emergency, we felt that law is a very important instrument that we should make use of it for the common people. That understanding which helped us to become a lawyer and make use of that in favor of the people who are hitherto denied access to justice. Much later, the legal aid to poor, everything came, but the communist parties were doing it even earlier without a legal aid movement.
So, thank you for spending so much time with us.